And now it's time for another case law update. Today we're discussing Byers Peak Properties versus Byers Peak Land and Cattle, LLC, a recent decision from the Supreme Court of Colorado that addresses whether Colorado's statutory waste of water provisions can be enforced by private landowners and what happens to the related trespass and nuisance claims when the statutory theory fails. Here's what happened. A Colorado ranch was divided into two parcels in the 1970s, an East Ranch and a West Ranch. After the split, the parties continued sharing irrigation infrastructure, including two ditches, and each granted each other easements for water conveyance. Over time, cooperation for the irrigation deteriorated. The owners of the East Ranch alleged that the West Ranch owner was diverting more water than it was entitled to use. According to the plaintiffs, the excess diversion caused irrigation runoff and flooding on their property. The East Ranch owner filed suit in Water Court Division 5, asserting several claims, including a declaration of waste under Colorado law, a statutory claim, along with trespass, nuisance, and requests for injunctive relief. The Colorado Water Court ruled largely in the plaintiff's favor. It found that the defendant had diverted excess water, violated the waste statute, and caused flooding. The court awarded nominal damages, granted attorney's fees, and entered an operational injunction restricting the defendant's ability to divert water in excess of its decreed rights. The defendant appealed. The key issue before the Colorado Supreme Court was whether the plaintiffs even had standing to bring a statutory waste claim in the first place, and whether those statutes create a private right of action. The court held they do not. First, the court explained that the Colorado statute regarding water waste contains its own enforcement mechanism. Violations are prosecuted in the name of the state. Because the legislature provided a specific public remedy, courts will not imply a private one. As a result, the plaintiffs lack standing to seek a declaration of waste under that statute. Second, the court held that the Colorado statute does not apply to flooding damage caused by irrigation runoff. The provisions in question are aimed at protecting water rights from over-appropriation, not compensating neighboring landowners for surface water impacts. That meant the statutory claims failed, and the award of attorney's fees could not stand either. Once those statutory claims were out, the jurisdictional structure changed. Water courts have exclusive jurisdiction over water matters. But here, without a viable statutory water claim, there was no remaining water matter tied to the alleged waste and flooding. The court concluded that the water court lacked ancillary jurisdiction over the related trespass and nuisance claims. Because the underlying claims failed, the operational injunction fell with them. So why does this matter? First, Colorado's waste statute is not a private enforcement tool. If you represent a landowner dealing with irrigation runoff, you cannot simply plead the specific statute and assume you're in business. And second, not every dispute involving water belongs in water court. If the claim is really about property damage, rather than the right to use water, it may belong in district court. That's it for this case law update. I'd like to thank Jacob Wilson, an associate in our Denver office, for his help on this update.